Hey everyone, this is Eddie, and I would like to welcome you to this initial impressions video of the California Bar Exam, February 2017, question number 2. Now, initial impression, all this means is that literally it means initial impressions. So I have not seen the exam yet, and this information is just based on, again, initial impressions. And let's see, the last time I did a video on the subject of initial impressions was for July 2016, and the civil procedure question and the question that dealt with the choice of law. Now, before looking at the actual exam, at the hypothetical, I said, hey, look, it doesn't matter if you said that you must apply California law or that you must apply FRCP, or even if you did not mention any law. Now I said that, and it was correct. And if we go back here at let's see now, if we look at bar essays, for example, some of the responses that did not even include a choice of law received some of the highest scores here. For example, let's look at this one here. Look at that. This examiner did not mention California law or FRCP, but that's in the past. Let's now focus on February 2017. So my initial impression here is that there were many responses to this. And of course, the foundation, the question that you need to ask is whether you did a fantastic job in analyzing the issues there. And there was an elephant in the room there, all right? And that's the possibility of torts being present. And more specifically, was there a duty to disclose a murder? And was that duty breached? Now, the bar graders want to know if the examinees handle pressure under uncertainty. And there seems to be in every exam one of those questions where it's just helter skelter and everything. Everyone just kind of responds in a different manner. And what the bar graders want to see is they want an answer that is responsive, organized, and heavy on analysis. And here's something to remember. It is important to use the facts and develop the rules and elements from the facts. Now compare that to when an examinee will use make up rules and then make up facts. Okay, so there's a danger in that because you may run out of time and you may not get a chance to develop and analyze the facts. So hopefully a lot of people, that wasn't the case for many people here. Now, when the majority of the responses differ, there is leeway in the sense that examinees may use rules incorrectly, and they may still receive a passing score. That happens. That happened in February 2016 in a question that dealt with the Uniform Commercial Code. Look at question 6, and even for July 2016 for that civil procedure question, there was an issue that dealt with giving notice, and people said, "Hey, you need certified mail or priority or through personal service," and some of these responses were given a passing score. So just keep that in mind. And let's see the area of law here. So let me see, this thing is moving here. So we could be in torts, we could be in contracts, and then of course remedies. Let's talk about torts first. Now, there may be a liability for failure to disclose, and whether that liability attaches depends largely on the facts. And some of the questions that I have are these: did the seller know of the murder? Did the seller have a duty to disclose the murder? Now, just because there was a murder there does not necessarily mean that a duty to disclose that attaches. That the murder caused the diminution of the land, and how long ago that the murder occurred. Now, at common law, the principle of caveat emptor is controlling, and you may have strict application. Now, compare that to statutory law. Now, I'm not saying that California is going to apply, just to get a sense. In California, a seller does have a duty to disclose whether the murder took place if the murder took place within 3 years. But probably in common law here. So the answers are going to vary, like I said earlier. But without more facts, I would say that liability under torts is not attached. Again, I have not seen the actual question. But as a general rule, if I'm not given many facts, I'm not going to spend much time on an issue. And there are plenty of other issues that we can respond. So let's go to that now. Let's go to the possibility of contracts. Now, I want to know if fraud was present. And I think that's one of the questions that they specifically asked you. And here's some things that I want to know. Was there a material representation? Or was it false? And as far as the materiality of a representation, it cannot be inferred. So was there a specific statement? And was the buyer induced by that representation? Did the buyer rely on any representation? Did the seller commit fraud by omission? These are just questions that I have. Now, it could be that the buyer was induced by the representation that a parking space would be available. And for it to be a material representation, a party has to show that he was induced by that statement. So this is going to be key to explore. Now, it is possible that the seller knew that the parking spot was not permanent, and there may be a duty to disclose. And by omitting that fact, it could be that the seller can be found liable under a contractual fraud theory, and he can play with the facts there. Now let's move on. Let's see the seller's defenses and the parole evidence rule. I'm thinking that the clause for a specific parking space was probably not included in the deed, and it could be that the seller could say, "Hey, it's not going to be admissible." And some of you can already say, "Hey, look, there's exceptions to that." And one of them, of course, is the oral condition precedent. It can be admitted, but I want to know this: was the language was sufficient to form a condition, or was it a promise? That's going to be important. We need more facts on that. Now, was there fraud? Because of course, this also falls under the parole evidence rule as an exception. Another exception, of course, is we're stating here could be fraud, and the court can allow that statement, and the buyer can say, "Hey, look, the seller knew that the parking space was not permanent, and he knew that I relied on that statement." So you could definitely make arguments either way. And let's see now. Let's now talk about remedies. So there seems to be a difference of $40,000 in value, and there seems to be an incurred expense of $50 for that parking space. And the question that needs to be addressed here is what caused that decrease in value? Was it the murder or an attempt at an improvement? And I think if you explore this thoroughly, you get many points here. And by analyzing the remedy, I want to say this. It doesn't mean that any party will prevail. And the conclusion is not something that the graders are going to focus on or give more weight than the analysis. And I keep saying this, that the analysis is going to determine the bulk of the points that you will receive. Rescission, you have to address that. That would have been helpful. When there's fraud, and then one of the remedies there could be rescission. Compensatory damages. I want to say this about compensatory damages. That this has various categories. For example, it has expectation, consequential, reliance, incidental damages, but it also has its own elements, as we can see here: causation, foreseeability. And I think there's where you could have mentioned the decrease in the value of the property. And I think if you did address that issue here, you did extremely well. And if you did not address it, I think you could still receive a passing score if you did very strong on a very strong analysis on the other issues. And there was a murder and the bathtub. You could definitely take these elements: causation, foreseeability, certainty, and address these facts. Now, expectation, let's see. Now, you can mention the contract price and the market value. And we have there the value of the home. And we have the parking space. And let's see, consequential, anything that is foreseeable, address that. Reliance. Okay, let's talk about reliance. So there, the plaintiff seeks to be in the position that he would have been had the contract itself not been entered into. So, in other words, we're looking for reimbursements that the party that was harmed that he made out of pocket. So, we're looking for out of pocket losses. And here it does seem that the buyer made some kind of improvement. Did the buyer make other purchases? So, you need to consider that. For incidental damages, you have to consider damages that were reasonably associated to the breach. And there seems to be an amount of $50 per month, and there seems to be a parking space that was an extra block away. And I want to know if the buyer had to pay to search for a new parking space. So that could be something that is associated to the damages. So for incidental, sometimes you have to come up with damages that are not specifically mentioned in the fact pattern. And can you think of extra expenses there? And restitution. Now, again, I'm not saying that a party is going to be liable for restitution, but you do have to explore this. And you definitely have to consider whether there was wrongful conduct on behalf of the seller. Now, let's talk about punitive damages. So, in general, they are not recoverable for breach of contract, but word of caution there. Do not go beyond the scope of this statement by saying that punitive damages cannot be awarded in all contractual settings. For example, remember that punitive damages may be awarded where fraud is present, and you may have a case of fraud in the inducement, and a party there can be awarded punitive damages. So I hope this helped, and I hope that everyone here passed. I wish you all the best. Until soon.